This year, we are moving forward to the topic live in American culture today of executive orders and how they work. George Washington was the first executive to do executive orders. He issued 8 of them in his 8 years. Thomas Jefferson, only 1. Late 1800s, presidents have increasingly begun using these executive orders, most often as tools for operations management, but also in signaling directions to advance the goals of the current party in power. This session will give the audience a high-level overview of executive orders and their role in the lives of Americans, and then come down to a case study. Paul Rosenzweig, the first speaker, who is unable to be with us because of logistical reasons, but will be winging in electronically from Costa Rica, will describe briefly the history and purpose of such orders, the process involved, and the constraints around them. Executive orders are a valid tool so long as they are within the scope of the executive branch and do not override federal laws and statutes. We'll hear about today's growing controversy regarding such orders and how the current president's executive orders can be seen as advancing his party's political agenda. Our second speaker, I'm happy to say, is with us here. I'll introduce her in more detail in a few minutes. Nancy Weiss will bring the topic close to this audience. She will speak about an executive order directing the Institute of Museum and Library Services, our great friend IMLS, to reduce its activities to the minimum required by law. She will examine the legal framework that governs the IMLS, which plays a crucial role in supporting museums, libraries, cultural institutions in the US, and the implications of executive action. As I said, Paul Rosenzweig will explore the history, process, and purpose of executive orders. Nancy will proceed to talk about the case study affecting this audience. So I will now introduce Paul Rosenzweig. He is a consultant attorney and author, practices law in DC, specializing in legal issues relating to national security and homeland security. He is the founder of Red Branch Consulting PLC, a homeland security and cybersecurity consulting company. Formerly served as Deputy Assistant Secretary for Policy in the Department of Homeland Security. He's also currently a professorial lecturer in law at George Washington University and a senior fellow in the Tech, Law, and Security program at American University. Mr. Rosenzweig is a cum laude graduate of the University of Chicago Law School. He also has an interesting MS in chemical oceanography from the Scripps Institution of Oceanography and a BA from Haverford College. Following graduation from law school, he served as law clerk to the Honorable R. Lanier Anderson III of the United States Court of Appeals for the 11th Circuit. He is the author and co-author of a number of works and a video lecture series in his area of specialty. He is also a member of the Literary Society of Washington. We will now turn this over to Paul.
Good morning. Can you hear me? Can you see me?
Yes, we can hear you. And we can just see you and your slides. Go ahead.
Well, that's all you need for now. First off, thank you very much to the Charleston Conference and particularly to Ann Okerson for inviting me, and to you, Jim, for so ably stepping in at the last minute. I appreciate the invitation very, very much. Second, I do want to apologize both for not being there and for what I'm afraid will be a kitten-killing series of slides. Edward Tufte, the great graphic designer, said that every time a slide was shown that had more words than pictures, a kitten dies somewhere in the world. And I'm afraid that my slides are kitten killers, but hopefully they'll serve as mnemonics for you to kind of guide you as we go through this discussion. By way of background, my experience with executive orders stems mostly from the national security space. And oddly enough, I can report that that's also my connection to libraries. The American Library Association is a client of mine, and for many years I've advised them about issues like national security subpoenas to libraries and things like that. So this experience is a wonderful confluence of events, and so I'm really delighted to be here, and I thank you for it. So this is my, I just want to check, the slides changed for you as well, yes?
Yes.
Yes?
They did.
Good. Okay, then we are technically fine, which is always always something you need to test. This is my agenda for the day, the objectives that I have for you. I want to tell you about what executives are and give you a little bit about their history and use, kind of amplifying on the very brief introduction that Jim gave you. I want to describe how they interact with something that is at the core of President Trump's assertion of authority, something known as the unitary executive theory, which has been around for about 100 years, and then transition to what's happening today across America as a result of changes in the way that the president is implementing his executive authority now and what some of the reactions are to be. All of that will, I think, in the next 18 to 20 minutes, introduce you to the topic and set up Nancy's discussion well. And Jim, an invitation to you, if I wind up going on too long, I can't see a clock from here, please step up to the mic and cough loudly so that I stop at an appropriate time if I'm rattling on too long, okay? So let's begin. I want to start with some things that are pretty basic in the world, which is that where do we get law from in the United States? And traditionally, there are 5 buckets of sources of law that guide the operations of our government and of our citizens across the country. Most obviously, the United States Constitution, which has been around for 247 years now. There are federal statutes ranging from how we pay Medicare to how we manage the air traffic control system to how we pay for food stamps. All of those enacted by Congress, adopted with presidential acquiescence or over his veto. Those statutes, in turn, are embodied and implemented through a series of much more detailed regulatory structures that direct federal agencies and citizens on what those statutes mean. And then, of course, there are state and local laws and regulations as well. You're in Charleston, South Carolina. You're paying a hotel tax that's based on South Carolina law that is not related to any federal law, but is equally what we would call law. The unique aspect of this, and the reason I start here, is that all of these are essentially binding on everybody. You don't get a choice to whether or not to obey a federal law. If a federal regulation applies to your business, you don't get a choice as to what to do. If you get an order from a court enforcing a requirement, you don't get a choice. And that, I think, is a critical piece to understanding why executive orders are different. They aren't binding on everybody. They are instead internal directions from the executive branch to itself, telling it what it's going to do. So anybody who tells you that the president's executive orders are the law of the land is not actually speaking accurately. They are the law of the executive branch and nothing more. They are, for those of you who might have been in the military, think of them as command direction from the commanding general. This is what we're going to achieve. We're going to invade Iraq. And then that flows down to how we do it and why we do it. But that's the direction that somebody gives. A recent example that's kind of non-controversial, and so just to kind of explain how this works in practice, would be the executive order that President Biden issued in the last year of his term on artificial intelligence. Artificial intelligence is, as I'm sure you're all aware, a happening thing in America today. Probably most of you use it for things like ChatGPT and the like. It is also a happening thing in the federal government. And what President Biden assessed was that there was a lack of coordination across the federal government as to how it was being used and how it was being implemented by the various agencies. They adopted different formulations, they had different standards, they had different definitions even. So he directed the agencies that were most importantly involved in artificial intelligence development, the National Institute for Standards and Technology, the Department of Homeland Security, Commerce, and interestingly, Health and Human Services, because AI turns out to be a significant player, of course, in medical diagnosis, to coordinate their actions. And he told them what he wanted them to do, which was come back to him with a single unified plan for how the federal government would use artificial intelligence, how it would define it, how it would purchase it, how it would implement it, and also to review all the existing federal laws that apply to artificial intelligence and identify gaps. Tell him where new laws might be needed, which old ones might need to be rescinded, that sort of thing. So that was a wonderful example of exactly the right way, or what I think of as the right way to use executive orders to organize the vast federal government towards a single objective. But as I said, most importantly, it was internal to the Biden administration. It did not purport to, and it could not contradict existing law. He could not tell an executive branch agency to go do something that was otherwise forbidden by law. And so that's the nature of what executive orders actually are. Their history is, as Jim said, you stole a little of my thunder there, Jim. Since the founding of the country, George Washington's first executive order was to organize his cabinet and tell it what to do and tell it to report to him on what they thought they should be doing, because he was starting a new enterprise. His second was the very first Thanksgiving Day Declaration, which is kind of cool to think about since we're coming up on Thanksgiving again right now. And the third, and his fourth one, which was probably his most substantive one of all, was a direction to all of the cabinet agencies and all of the federal employees to maintain strict neutrality in the conflict between England and France. And if you think back to that time, tensions were very high. There were some pro-French, a lot of very pro-French people who wanted to assist the French government in its war against England. There were a few remaining loyalists. And so it was important for Washington to give the command direction to say, no, we are going to remain completely neutral and officially neutral. And I want everybody who gets a copy of this to understand that that's required. The executive orders have been used by every president since then, except I love interesting factoids. William Henry Harrison, who, as you know, caught pneumonia and died shortly after his inauguration. And so he was unable to issue an executive order. That's your strange factoid for the day that you can take back to the library and regale your other reference librarians with if you want to. The current, initially, there were so few of these that they weren't numbered or identified in any way. They were collected, but they didn't have an official designation. The current numbering system that we use now began in the late 1800s, 1890s, actually, and through President Biden, the last of his orders was number 14,144. And of course, President Trump picked up with 14,145 with his first executive order post his inauguration. Why are executive orders important, especially in modern times? Why have they gone from 8 under George Washington to there were 22 under Lincoln to 14,000 in the last 100 years? Well, it really is a reflection of the changing nature of the federal government. As the federal government has grown, the need for coordination has changed as well. I mean, to see it, just a couple of statistics, right? The employee count in 1939 in the federal government was less than 1 million people. This is civilian only, didn't count the military. Today, it's about 3 million, so it's tripled in size. The cabinet has grown. There were 4 cabinets under Washington. Today, under Biden and now under Trump, there are 10 cabinet departments, 15 cabinet departments, and 10 agencies like the Environmental Protection Agency that aren't departments of the government but are cabinet level in their activity, and so they are of equal legal importance, if you will, across the actions of the federal government. Coordinating such a large institution is essentially impossible, right? There are far too many things that are happening for any one man or even a small executive branch staff to really get a handle on. So what happens today increasingly is that the president uh, undertakes to tell people what he wants them to do by putting it in paper and passing it down to the cabinet levels, where the cabinet heads, the cabinet secretaries are intended to implement it, and they in turn pass it down to the assistant secretaries, and so on down the line. And we'll see some examples of that in a couple of minutes. I want to pause here and talk about something that isn't an executive order really, but is important to understanding the executive orders that are being used today. And it's something called the unitary executive theory. And it's been around for about 100 years, ever since the New Deal of Franklin Roosevelt, which I should say was a violation, and I put violation in air quotes with my fingers because it's not clear what a violation means, but it was a violation of the theory. The unitary executive theory says that all of the executive authority of the United States is vested in the president, and it comes from the very first clause of Article 2 of the Constitution, which is known as the vesting clause, and it has two parts. The first is that the president has to have complete authority over all of his subordinate executive actors. So, notwithstanding any restrictions on what he may say or do, he's entitled to make a direction to them if he wishes. So, under this theory, for example, it is perfectly appropriate for the president to tell the attorney general to indict somebody. It may be a violation of a norm or a good practice, but the unitary executive theory says it's perfectly legal. And the corollary of that is that under the unitary executive theory, Congress can't break the unitary executive. It can't create independent executive actors. The New Deal, as probably most of you are aware, broke that theory. It created the Federal Trade Commission, whose commissioners were immune from being fired by the president without good cause. It created the Federal Reserve. Well, the Federal Reserve is a little older, it goes back to the 1890s. But Federal Reserve governors couldn't be fired, and so on and so on. And in the 1930s, when people challenged this creation of independence and the existence of subordinates who weren't completely subject to executive authority, the Supreme Court rejected the challenge. It rejected the unitary executive theory in a case called Humphrey's Executor, if you want the name of it. More recently, however, the Supreme Court has been cutting back on that rejection and has been embracing the unitary executive theory, has been turning back to the idea that a president has complete authority over all subordinates. There are no independent people. And as we will see, this is why his executive orders to the IMLS and to others are given legal effect, because under a unitary executive theory, he can tell them all what to do, no matter what. There's a pending case before the Supreme Court, Trump v. Slaughter, in which the independence of the Federal Trade Commission is going to be tested. And if the court overrules Humphrey's executor there, then the unitary executive will be the theory of American governance going forward. There may be an exception for the Federal Reserve. The Supreme Court has hinted at that. But otherwise, the court will have adopted the view that the entire executive branch works directly for the president without any possibility of independent authority. I want to take one more detour here and talk a little bit about the close cousin of executive orders, which are presidential declarations. They are the same as executive orders in that they are statements of the president that are expressions of his policy. They differ in that while executive orders are inward looking, presidential declarations are designed to trigger authorities and have outward effect. And these have been many of the more controversial of President Trump's actions, but they stem from the exact same legal ground, which is that the president has plenary authority to direct the operations of the federal government. When he makes such declarations, that allows the invocation of other executive emergency authorities. So recent examples of this are the president's declaration that Tren de Agua, the criminal gang, is an invading enemy alien group that has crossed the national borders and that we are being subject to invasion, and that allows him to invoke the Enemy Alien Act. He has declared that the trade deficit is a national security emergency, and that has allowed him to invoke the International Emergency Economic Powers Act, IEPA. And he's declared that he can't successfully enforce the federal laws in cities around the country effectively without the National Guard being federalized and deployed. And you'll recognize all of these from the news today. The tariff case was argued in front of the Supreme Court just this past Wednesday, and we should hear what the Supreme Court says about that. There is a pending appeal of a prohibition on National Guard in Illinois that is awaiting decision as well. But the theme that unites all of these is deference to executive authority. The idea that executive declarations, whether in executive orders or in executive declarations, is not really subject to review. So that brings us to the last couple of slides and where we are today. President Trump is using executive orders in 3 different ways, big buckets. The first is he's using executive orders to make policy choices. And this is kind of the most traditional way a president does these things, though the way that this president has done it has been controversial. The most recent of these that you may have saw in the news just yesterday was his direction through executive order to the broad executive branch to that there are only 2 sexes, and that those sexes are determined by your biological sex at birth. In implementing that executive direction, the Department of State changed a rule that had been around for over 30 years, which allowed individuals to select their own gender identifier on their passport. So if you wished, even though you had been born biologically male, you could, because of your own personal views and desires, ask for an identifier as female. There's even a slight twist to that because more recently they've allowed identifiers as neither, but that wasn't an issue in this case. The State Department, implementing President Trump's executive order, rescinded that 30-year-old rule. And if you apply for a new passport today, the only identifier you can select is the one that you were born with, so to speak. And yesterday, the Supreme Court said that policy choice is within the executive branch's authority to do. There have also been, as I said, assertions of the authority to fire people from their jobs because of the president's plenary authority over the executive branch. The FTC case I mentioned involved the firing of all of the Democratic members of the Federal Trade Commission and none of the Republican ones. Likewise, the president has sought to fire one of the Federal Reserve Board governors, a woman named Wilcox, who was appointed by President Biden. Those are being resolved. They haven't been as definitively resolved as the policy choices one, but with the exception of the Federal Reserve case, it seems likely that the president will get his way on that as well. And then there are the structural restrictions, directions at how the executive agencies will act. This would include the shutting down of USAID, the closing of most of the Department of Education, the shutdown furloughs and SNAP payments that are part of the ongoing discussion today. All of these are couched as directing the executive agencies to do that which is minimally statutory necessary. And that's what Nancy will be telling us about in just a few minutes. So, final thought. What's been the reaction across the country, right? Essentially, where we are today, Congress has acquiesced. They have the power of the purse, and they haven't done anything with it so far, at least not that I can tell. And they've, as you all know, been in recess for the last 7 weeks. Meanwhile, I will say, and I should have put it on the slide, but the one bit of pushback seems to have been in the Senate, where a few of President Trump's tariff declarations, which aren't executive orders but are those presidential declarations, have been rejected by the Senate. But they haven't passed the House yet, so So they've just been expressions of unhappiness rather than effectiveness. Meanwhile, the courts have been a mixed bag. The lower courts have generally been more willing to restrict the president's executive authority. As you'll hear, the IMLS case is an example. So is the order just yesterday that the president must pay out the SNAP benefits. But the Supreme Court has not yet substantively restricted President Trump's authority in any way. And we're all waiting to see how that plays out in the next year. And then the last question that I would leave you with is, popularity, public popularity. What does the public think? And we may have gotten some indications of that in the elections last week, but those may not have been nearly as determinative as we like. And again, we'll have to see more about that as time goes forward. So that's a quick romp through the history of executive authorities. I'm going to mute myself, but stay here for questions and answers after Nancy's talk. Back to you, Jim. And I'm going to stop sharing the screen as well.
Great. Thank you, Paul. So, thank you, Paul. That was a tour of the landscape. We now move to a focus. The camera will zoom in a neighborhood that we are closely concerned with. So let me now introduce properly Nancy Weiss. She is principal of Culture SQ Capital Strategies, as well as senior fellow and adjunct clinical professor at American University College of Law. She previously served as the Kamenstein Scholar in Residence at the U.S. Copyright Office and as the first general counsel of the U.S. Institute of Museum and Library Services. And for how long, Nancy?
Oh my gosh, 24 years, but outside counsel included 27 of the 30 years.
27 years, she says. A serious and seasoned senior administrator. She was also senior advisor to the chief technology officer in the White House Office of Science and Technology Policy. She's represented the U.S. government on delegations to the UN World Intellectual Property Organization, WIPO, to UNESCO, to the United Nations World Summit on Information Strategy, the Organization of American States, and the OECD. She's played a key role in drafting international instruments pertaining to copyright and digital content, cultural activity and expression, human rights and information policy, and Nazi confiscated art. Earlier in her career, Nancy served as Deputy General Counsel for the NEH, practiced litigation and media law at Williams and Connolly, and held a federal judicial clerkship with the Honorable William W. Schwarzer of the Northern District of California. She graduated with honors from the University of Michigan Law School and is Phi Beta Kappa with a degree in economics from the Wharton School of the University of Pennsylvania. Supporting her in her talk will be the Toronto Blue Jays Beanie Baby. Nancy, the microphone is yours.
Thank you. Now that you have the doctrinal framework, I'm going to walk through a case study. We're going to, there we go. We're going to review a recent executive order, learn about the agency that was one of the subjects of it, and discuss how things are playing out. And whenever I'm in a room like this, I always think of Joan Rivers. Can we talk? You know? So just to get started on the discussion. On March 14th, President Donald Trump issued Executive Order 14238 with the purpose of reducing the elements of the federal bureaucracy that he, as president, determined were unnecessary. The order identified seven federal agencies and programs, including the Institute of Museum and Library Services. A few days later, at a town hall meeting, employees were informed by leadership that they anticipated that the agency would be stripped down to the studs. A few days later, on March 20th, Deputy Secretary of Labor Keith Sonderling was sworn in as the acting director of IMLS. And on March 31st, all current IMLS staff were placed on administrative leave. So when you're sent home, you get paid, but you have no access to anything, including email. The next day, 12 employees were recalled, and the day after that, grants to California, Connecticut, and Washington State were terminated, and a few days later, an additional 1,200 competitive grants. So that's setting the stage. Now, there have been other executive orders. As we've talked about, they've been around for a pretty long time. One of my personal favorites is Executive Order 14084, Advancing the Arts, the Humanities, and Museum and Library Services. This actually builds on an executive order that was signed by Ronald Reagan in 1980, establishing the President's Committee on the Arts and Humanities as advisory committees to the National Endowments for the Arts, Humanities, and the Institute of Museum and Library Services. So this was an update from 2022 that just delved a little bit more into the role and the way that the cultural agencies work with other agencies throughout the government and also with the White House. But Executive Order 14238 of March 14th was just a little bit different. I actually worry about those little kittens. There is a lot of text in my slides, a few pictures, but I also want to make sure that you have a resource that's available to you. So think of it that way. You don't have to look at them now. These will be made available to you. But about that executive order. So it says, you know, that under the authority invested in me as president, Donald Trump, I have determined that some agencies are unnecessary, and for that reason, I am directing that the non-statutory components and functions of the agencies, including IMLS, Institute of Museum and Library Services, shall be eliminated to the maximum extent consistent with applicable law. And IMLS shall reduce the performance of its functions to the minimum presence and functions required by law. So that's the executive order. Within 7 days, the agency was directed to submit a report confirming compliance with this. And the Office of Management and Budget, which controls all of the monetary disbursements in the executive branch, was told that it should reject funding requests for IMLS to the extent that they're inconsistent with this order. But of course, nothing in this order should be implemented in a way that is inconsistent with the applicable law or the appropriations. So this goes back to what Paul was saying about executive orders have a role, but they also need to be consistent with applicable law. So I'm just going to grab my water, but I'll let you look at this picture. What is the Institute of Museum and Library Services? It's an executive branch agency. It's actually technically in the National Foundation on the Arts and the Humanities, which exists on paper, but consists of 3 separate agencies: the National Endowment for the Arts, the National Endowment for the Humanities, and the Institute of Museum and Library Services. IMLS, by its legislation, is a, quote, independent agency. But I will say that in this case, that means that it's not a cabinet agency, it's not a department, but it is a separate agency, and the director reports to the president. IMLS is the primary support for museums, America's museums and libraries, and its statutory mission is the director shall have primary responsibility for the development and implementation of policy to ensure the availability of museum, library, and information services to meet the needs of the people of the United States. In carrying out this directive, the statutory directive, the law further provides that IMLS shall advise the President, Congress, and other federal agencies, engage in federal, state, and engage pretty much everybody in developing plans to support the provision of services, carry out programs of research and development and data collection and financial assistance. Most people think of IMLS as a grant-making agency. There are a lot of different functions that the agency has in carrying out its mission, including ensuring that museum, library, and information services are integrated into the information and educational infrastructures of the US. So IMLS is a tiny little agency, as we'll hear, but it does have a pretty big mission. And it goes back a long way. So the current legislation is the Museum and Library Services Act, and it was actually reauthorized in 2018 by President Trump. But it includes a combination of laws that go back to 1956 in the case of libraries. So it was the Library Services Act, the Library Services and Construction Act, and now the Library Services and Technology Act. But even though the law itself goes back to 1956, actually these go back, the programs have some roots in 1938. So think back to that Roosevelt era. And the agency was actually created because at that time there was, as this picture reflects, a problem for the nation in the lack of library services in rural communities. So over the years, as the legislation grew, it grew with the development of the United States to fund rural libraries, urban libraries, individuals with disabilities, special needs, and in 1984, also direct services to tribes, Alaska Native communities, and Native Hawaiian organizations. So there's a lot that is covered here. And basically meaning that everybody in the US, wherever located, should have access to services. Now, the museum services component of the agency dates back to the bicentennial, when there was a focus on making sure that people had access to the collections within the museums and their educational programs, and also a focus on preservation, something to think about as we are approaching our 250th anniversary. And people don't always recognize, but IMLS actually fostered the creation of the Heritage National Emergency Task Force, which provides tools for disaster planning and response with FEMA. And so there are a lot of different important functions that are carried out by this agency. So there's a lot that's put in here together in the Museum and Library Services Act, and there's also other statutes that establish programs for IMLS. So you just see them here. I'm just going to go past them. And I just also like stopping for station identification. There are approximately 124,000, 25,000 if you look at that, libraries in the United States. I really like this poster that says Public Libraries, an American Contribution to Civilization, because we really do have a very special infrastructure in the US, as well as 33,000 museums, which include art, science, technology centers, children's museums, etc. Okay, so back to our story. After the executive order was signed on April 4th, 21 states filed in the U.S. District for the state of Rhode Island, claiming that the executive order caused immediate and ongoing harm, including loss of services, forced layoffs, and canceled programs. On April 7th, the American Library Association and the American Federation of State, County, and Municipal Employees filed a lawsuit in the U.S. District Court for the District of Columbia, challenging the efforts to dismantle the agency. There, the defendants include IMLS, and its acting director, President Trump, DOGE, the Department of Government Efficiency, and the U.S. Office of Management and Budget. So to be able to understand these lawsuits, you kind of need to know a few different legal doctrines, and that's what this is. The Constitution, dating back to 1789, has a few clauses. One concept is the separation of powers, and that is only Congress can draft laws, can implement laws. So Congress writes the laws, the executive branch implements them. So Congress is responsible for the law. The president, the executive branch, is responsible for implementing them. As part of this, Congress has the power of the purse. It negotiates, we know right now, as we're in a lapse of appropriations, but it funds the government. It passes appropriations laws, and those are separate laws. So again, Congress is the only one that can either establish an agency through a law or abolish an agency through a law. The president is subject to Article 2, Section 3 of the Constitution, the Take Care Clause. The president shall take care that the laws are faithfully executed. There's also a law called the Administrative Procedure Act, which is that agency actions need to have a rational basis, and a reviewing court must hold unlawful and set aside agency action that is arbitrary, capricious, and abuse of discretion, or otherwise not in accordance with law. So you'll hear that a lot. You can't be arbitrary and capricious in the government. There's also, finally, the Tucker Act. And that's actually a way that somebody can bring an action against the United States. Usually the government has sovereign immunity, but the government will pay if you have a claim, such as a breach of contract or, as you will see, potentially not getting a grant. So if you know these 4 items, you're in the know. I'm going to move on. So again, back to our story, the 21 state attorney generals filed a lawsuit in Rhode Island, and District Judge John McConnell, who, by the way, is also the judge in the SNAP case, so he's getting a lot of work done here. He issued a preliminary injunction, and he found that the states had suffered and would continue to suffer concrete injuries due to the agency's actions. And he said, I see a violation potentially of the Administrative Procedure Act, as well as the constitutional provisions that we just talked about. And so he issued actually a pretty broad injunction saying you've got to reverse what you did. You've got to bring everybody back and resume the grants. And by the way, give me a report on your status within 7 days. The government appealed to the next higher level, the First Circuit Court of Appeals, and because they wanted to basically stop the preliminary injunction. They asked also for a stay. That means pause your, preliminary injunction says stop everything, go back. They asked for a pause in that injunction as the case goes forward, and then you can see we're in real time here. The First Circuit denied that request. The injunction is still in effect. Moving on. I put in just a reference to the agreed statement of undisputed facts. You know, basically, right now we're in a posture where there are a lot of proceedings going on known as summary judgment, where the parties say, okay, given these facts, as a matter of law, you have to decide one way or another. So the plaintiffs filed about 300 pages of facts on all of the agencies, and 4 agencies are involved in this particular case. And I just thought it was interesting, and I love librarians because 2/3 of them were about the harm to libraries. And these are actually worth reading. So, as I said, actually, even though the government is shut down, this case is actually proceeding. The judge said that this has to move forward. There's actually a pleading that is due today by the government and in the district court, lower court. And then in December, the First Circuit Court of Appeals will hear oral argument about the injunction. But that injunction is still in place and ongoing. Lots of words. But all you need to know about this is the American Library Association case, and is that ALA did file this case with the AFSCME, and Judge Richard Leon in DC granted a temporary restraining order. And you can see, because he also thought that there were violations. But that temporary restraining order expired. And the judge actually denied a motion to continue the restraining order because of some Supreme Court precedent that said maybe the Court of Federal Claims would be a more appropriate forum than the district courts, because really this is sounding like it's a breach of grant funds. And so this goes back to understanding the statutory basis. So in these cases, is this really about not getting grant funds, or is this about dismantling and not complying with the structure of the statute? And part of the reason why the states filed is because the Museum and Library Services Act actually has a federal-state partnership that has been in place since 1956, where federal funds are used to help establish the infrastructure of the state library administrative agencies to make sure that there is library services throughout the states. And so, is that a grant, Tucker Act, go over to this other court, or are there the constitutional arguments here about separation of powers? That's what we're experiencing right now. I'm just going to complicate it once more. Oh, I should also say, unlike Rhode Island, the judge in DC said, and this is the court rule, that when the government is shut down, all proceedings are paused. The next step will be the government has a pleading to file 10 days after the government reopens. Okay, so finally, and we're kind of braiding things here, I wanted to mention what's happening in Congress, because again, you've got your authorizing legislation, and I'm nearing the end here, your authorizing legislation, and then you get your appropriation. There is a mistake in the slide. So, on March 14th, the president signed the executive order, right? Saying you have to do everything consistent with law. On March 15th, 2025, the next day, he actually signed into law the full year appropriation for fiscal year 25, the government year, at $294.8 million for the Institute of Museum and Library Services. So just remember that. In June, the Trump administration put in a budget request of $6 million to shut down the agency. But prior to the government shutdown, or this lapse in funding, both the House and Senate Appropriations Committees recommended an IMLS budget of $291.8 million for the year going forward. In addition to that, so there's some congressional support here. And that goes to what Paul was saying. There have been cases where Congress has ratified, really, what happened under the president. And, you know, we're getting some indications that Congress wants these programs to stay. In addition, there's something called the Government Accountability Office, and that is Congress's oversight an agency that makes sure that federal agencies are carrying out Congress's desires. And they actually issued an opinion in June saying that IMLS violated the Impoundment Control Act when it withheld the appropriated funds. It impounded the funds, and actually made a statement about all IMLS funds, that it was inappropriate to do that, period, withhold the funds. There are some steps to either rescind the funds or defer them, but it also made a finding that you can't do that with respect to the grants to states funds under the statute. So that is kind of an interesting development. And GAO, in my experience, has only issued 2 opinions for IMLS, so this was actually kind of a big opinion. So I'm just going to end here with what is the road ahead. This is my favorite cartoon. It says, "The week at a glance," and it shows a man behind his desk not looking too happy, because I think we're really, again, watching what's happening at the courts, but just as importantly, watching what is happening on the Hill. And then I just did want to end with some hopeful sign. So I hope you're also appreciating the different Public Domain American Library Association posters. And thank you, and I look forward to the questions.